This case opens with a deceptively simple request: remove a GPS monitor. But make no mistake, this is not a routine bond modification. This is a courtroom weighing public safety against personal rehabilitation, and the stakes could not be higher. Kelly Cotner is facing a third-degree felony DWI. Her third or more offense with allegations of over 8 prior DWI is E. That alone places her squarely in the high-risk category under Texas law. What complicates this case is the human element. Cotner presents herself not just as a defendant, but as a caretaker to an elderly veteran who depends on her daily. She argues that the GPS restrictions prevent her from helping him in real-time emergencies. Meanwhile, the state argues something far more blunt. GPS isn't about convenience, it's about control and prevention. This hearing becomes a tug-of-war between compassion and caution. The judge isn't questioning her sincerity, the court is questioning risk. And as this unfolds, you'll see how judges dissect logic, not emotion, when community safety is on the line. So here's the question to keep in mind as you watch. When someone has a long DWI history, how much flexibility is too much? And at what point does personal hardship stop outweighing public danger?
Is calling 2024 CR 6359, State of Texas versus Kelly Cotner. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
George Sharman on behalf of Ms. Cotner.
Ms. Cotner?
Yes, Judge.
All right, defense has filed a motion to alter and amend bond conditions. They're asking for removal of the GPS monitor. State, do you have any objections?
Yes, Your Honor.
All right, state, what are your objections?
Judge, I believe this is the defendant's DWI for the protection of the community. We think that the GPS should stay in place. Again, this is for the safety of the community. This is something that it's been an issue where when she gets in a car, there's possibility that she could be drinking. So that's what the state's main concern is.
All right, is she on a ignition interlock?
Yes, ma'am.
Well, now, excuse me, don't do that unless you're called as a witness. Does ignition interlock address that issue or does it not address the issue?
Judge, again, the worry is that the frequency of the DWI is the number it's at. An ignition interlock on one car doesn't mean that she's completely unable to get into another car. So that's why the state's concern for GPS is also to have that in place to have extra protection.
All right, so how will GPS show she's not in a vehicle though?
Well, Judge, if she has any type of full house arrest or partial, we know where she is. We know what type of hours, what her blueprint's going to be. If she's not on GPS and we have no idea where she's going, she can leave her car with the ignition interlock there at her home and then immediately get into a car that's not with the ignition interlock.
All right, so she has put in here, or at least there's a letter attached to the motion stating that she is helping someone go to their doctor's appointments. So do you have any objections to her going to doctor's appointments with someone?
For her doctor's appointments, no.
No. It's to another person, Mr. Eloy Lopez. All right, first question, defense.
Yep.
Is this, the state has said that she has allegedly over 8 DWIs. Does she allegedly have over 8 DWIs?
That have been alleged, yes.
Okay. All right, so you've heard the state's concerns.
Well, I would like Ms. Cotner just to tell you why she needs to do this. Okay, Ms. Cotner, just explain to the judge why you need to get that off of you to help this gentleman. Why?
I am currently the caretaker for an elder gentleman by the name of Eloy Lopez Sr. And Mr. Lopez is 87 years old and he has some cognitive decline. And he's recently I helped him recover. I administered drops and home recovery from 2 cataract surgeries. He loves me like a daughter now. I do everything. I feed him. I wash his dishes. I make sure that he does not have any falls. He uses a walker to get around and he depends on me. And he cries and you know, he really cares for me and I'm enjoying and getting a lot of fulfillment out of helping this man because he genuinely needs this help. He's hard of hearing, and when he goes to doctors or stores, I'm very gentle and kind with him, and he's not afraid to speak with me, and I can understand what he's trying to say rather than a stranger who might not be familiar with him might yell at him and try to understand what he's trying to say. I've been able to do that with doctors nurses and secretaries, etc. And this man loves me like a daughter, and I would like to be able to take him in an Uber comfortably and assist him at the doctor's office, at the grocery store where he can pick out his favorite groceries, which I provide for him.
All right, why can't that be done with GPS?
This exchange right here gets to the heart of the legal issue. The judge isn't being dismissive, the judge is being precise. GPS monitoring isn't punishment, it's a preventative control. And the court keeps circling back to one key point. Why does the GPS actually stop her from doing this job? The state's argument is legally sound. An ignition interlock only controls one vehicle. GPS controls the person. That distinction matters, especially when a defendant has a history of multiple DWIs. From the court's perspective, removing GPS creates a blind spot, and blind spots are unacceptable in higher-risk cases. What's notable is that, even under questioning, Cotner admits she's been able to comply so far. It's been difficult, yes, but possible. That admission undercuts the motion. Judges often look for necessity, not preference. And here, the court clearly sees scheduling inconvenience, not impossibility. So let's ask you, should courts loosen restrictions when compliance is hard, or only when compliance is impossible?
Well,
No, she's on the witness stand. Why can't that be done with GPS?
Well, Your Honor, I've had no violations after 8.5 months on GPS.
No, my question is, why can't that be done with the GPS?
Well, I have to put in 24 hours notice for any GPS needs, which I've been able to do successfully for any needs of my own. But Mr. Eloy Lopez sometimes thinks right at the moment that he might need.
All right, State, with regards to her testimony, do you have any questions?
How long have you been employed by Mr. Lopez?
Since January of 2024.
And so far, you've had no issues reporting to probation or to pretrial any type of trip that you take to help him out. Is that correct?
Yes, sir.
So far, you've been able to accommodate helping him while also being on GPS.
Made it happen. It's been difficult, but yes.
Nothing further to say.
All right, any other questions?
well, Ms. Cotner, are you asking to be able to take him to other locations that you do not have access to right now?
Well, I have access to, what do you?
Well, in other words, you are in lockdown at home, correct?
Yes, sir.
Okay. And if he needs to go somewhere, you can't take him without permission. Is that correct?
Correct.
All right. Are you asking the judge to allow you to take him where he needs to go without having to contact pretrial services?
Yes, sir.
All right. So this is the court's suggestion. My suggestion is you all step back. I'm not going to remove GPS. The problem is, one, people in my court, I don't allow them to be home healthcare providers, and that's what she's doing. However, she's not been convicted of this offense for the court. So the occupation is her occupation. I'm assuming, hopefully, that the family knows her history before they hired her. So I'm not going to remove the GPS. Y'all need to step back and work on a schedule. And that will be her schedule because she is on partial. So y'all work on a schedule that includes the person that she is caring for. And I would suggest that an address for that gentleman be included in this. Kelly Cotner.
Ma'am, what did you say?
All right. Now, so for this case, there were some officer records or something
Yes.
in state.
We're not going to sponsor that officer's witness.
All right. But the question is whether you are going to sponsor the officer or not. Did that officer have anything to do with this case?
Yes, he did.
She did.
So then the question becomes whether or not the defense is just going to accept that that officer is not going to be called as a witness, because maybe they want to call the officer as a witness. I don't know. So where are we on that? Have you all conferred over that?
Well, not over that, I mean, he's not somebody I would want to call.
All right, so then do you need the records then? Since they say they're not sponsoring him as a witness, they're not going to call him.
That's correct. Now, because of that, there is a secondary officer that they intend to go forward with, who didn't make the arrest, who didn't make the stop. And I've got some motions I'd like to file on that.
Well, why? I mean, I don't understand why that hasn't been done. What motions need to be filed on that?
Well, I don't know that that officer can sponsor this other officer's stop and video when she wasn't even there.
I mean, well, that'll be something for you to take up at trial and see whether or not, and I'll make a ruling on whether or not that officer is allowed to testify. But whether or not that officer is allowed to testify, I can't make that decision unless you're actually in trial, because I don't know what the state's evidence is going to be. I don't know if that officer has any ties to this case whatsoever, tangentially or not. So that would be something that would have to be taken up at trial, whether or not that witness is relevant.
Well, there is an issue on the stop itself. But it is a video that was made by the officer that they're not going to sponsor.
All right. So what I'm saying is this, and I want everybody to hear me clearly to make sure that I'm communicating what I'm trying to say to you.
Yeah.
In a jury trial, witnesses will be called. I don't know anything about your case. The only thing I know is what you're charged with. I do not, and I'm not allowed to do a pre-jury trial where I hear everything and make decisions, and then people can then have a trial. So what will end up happening is the state will call witnesses. If there's a witness that the state intends to call and the defense thinks that that witness is not relevant, then I will make a ruling. If I determine that witness is not relevant, then guess what? That witness won't testify. For example, on your case, I know nothing about your case. Hopefully, Ms. Abrams knows nothing about your case. So if the state were to decide to call Ms. Abrams as a witness in this case that she knows nothing about, then you know what your attorney would probably do? Your attorney would probably say, Your Honor, I'm object to Ms. Abrams as a witness. She knows nothing about this case. Then you know what I will say? Ladies and gentlemen of the jury, if you'll step outside, we're going to have a hearing outside your presence. And then I will have your attorney to question the witness. He'll probably say, Ms. Abrams, were you at this scene? No, I was not. Do you know anything about this case? No, I don't know anything about this case. Then I will turn to the state and I will say, State, how is this witness relevant? And then if they tell me, well, she doesn't know anything, then guess what I will say? This witness is not allowed to testify. Ms. Abrams will step down. The jury will come back in. I will give the jury instructions and I will say, Ms. Abrams, the witness who was called, you're disregard any testimony that you've heard from her. It's as though she never even appeared. But I won't know if she knows anything about this case or not unless we're in a jury trial.
Well, then we do have some motion in limine issues on the case.
With the motion in limines, the way that happens, unless there is some legal reason that it appears that testimony or something cannot be heard, then I can make a ruling on it. But I can't grant motion in limines when I know nothing about the case. For example, the only way that I will be able to grant a motion in limine is, this is a DWI. Let's say somebody's saying you committed a murder also, right? That is unrelated to this DWI. With that, I can say that is not coming in whatsoever. But usually with motion in limines, it's different things where the attorney does not want certain things brought before the jury. And what I'll tell everybody is I'll say, look, state or defense, if the state has a motion in limine, I'll say, if you're going to get into the fact that she cut down Auburn's oak tree or whatever, I'll be like, y'all need to approach before you question that witness about that. And then the jury will go outside and then we'll talk about it. And I'll say, okay, what does her poisoning or cutting down the tree in Auburn have to do with this case? And again, if it has nothing to do with the case, I'll be like, it's not coming in. Or if I find that it's more prejudicial than probative, it's not coming in. but I can't make those decisions until I know what's going on with the case, because the only thing I know about your case is what you're charged with. I don't know any facts of the case whatsoever. I don't know. The only way I know about blood draws or whether was there blood draw or not is because of discovery issues that were asked for. So that's where we are.
Well, Judge, I do believe I have a right to file a motion to suppress the blood draw. I have a
Yeah, but
right
has that
to
been
file a
filed?
motion to suppress the video.
Has it been filed?
I'm going to file it now, but this is the first notice that I received that they're not going to use that witness at all.
Okay.
So I'm asking you to give me a 2801 pretrial hearing.
Well, you all need to file those and file it today, and it'll be heard today. Thank you.
I don't know that I can file it today.
This case has been going on since July 2024. And I know Ms. Cotner is ready for this case to be concluded. And this case is going to be concluded. So it needs to be filed today. We've been here forever on this case.
Well,
So
Judge,
file the
this
motion.
is the state's delay, not mine.
Mhm.
You understand that?
I do understand that. And what I'm
Okay.
telling you is motions need to be filed, and those motions need to be filed today. I don't know how many other ways I can say it.
Right.
Your
So-
motion needs to be filed today.
I will file it today, but it's what I heard you say you would hear it today.
File your motion. State, have your witnesses here. Discuss, confer.
Okay. Very good.
Kelly Cotner. Court is calling 2024 CR 6359, State versus Kelly Cotner. Could I have parties announced for the record for the state? Defense?
George Sharman on behalf of Ms. Cotner.
And are you Ms. Cotner?
Yes, ma'am.
Ms. Cotner, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes,
State,
sir.
are you proceeding on the indictment as presented?
No, Your Honor, waiving the habitual offender enhancement allegation.
Any objection?
No objection.
All right, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Well, all places. Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes,
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. The state recommends community supervision. Did you understand that to be the plea?
Yes, Your
All
Honor.
right, outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 10 days in the Bear County Jail as a condition, DWI intervention, victim impact live and ignition interlock for half the term. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
I'm going to set this off for sentencing because I need a TAP evaluation. Would you like a full PSI or just a TAP evaluation?
Well, let's do a whole PSI.
All right.
I think that would help you in the final sentence.
All right. All right. We're going to go on the record. Court is calling 2024 CR 6359, State versus Kelly Cotner. Could I have parties announced for the record for the state?
Harris Salem.
Defense?
George Sharman on behalf of the defendant.
And are you Kelly Cotner?
Yes, ma'am.
All right, you entered a plea of guilty on January 13th. A PSI and a TAP evaluation was ordered. According to your plea bargain agreement, punishment is to be assessed at 8 years in the prison and the state is recommending community supervision. All right, anything you wish to say on behalf of your client?
Judge, we're asking for probation for you to follow the plea bargain. Ms. Cotner has been monitored the whole time. She had no violations, and she's had this device keep her in the home. She hasn't been driving. I think she's done everything positive that she could do to show this court that she would be a good probationer.
All right. State you may be excused.
Thank you, Judge.
All right, this is what the court is going to do. The court is going to follow your agreement. The court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be a referral to felony drug court. Probation, she's already been accepted to felony drug court. They were just waiting for the outcome of her application. DWI intervention, DWI education course, VIP live, ignition interlock for half the term. There's to be 200 hours of community service restitution. Do you have any hobbies? What do you do?
Well, I like to read and go to AA meetings
Okay.
and visit with family and friends.
All right. So are you employed?
No, ma'am, I am retired, but due to expenses, I may have to seek part-time employment.
Okay. And who do you live with?
I live with a very nice elderly gentleman. He's a veteran. His name is Mr. Eloy Lopez Senior.
Mhm.
I rent the room in his home.
All right, so there's going to be 200 hours community service restitution. How often are you doing AA meetings?
Usually I try daily, but I would average 3 to 5 times a week minimum online because I've been under and am currently on 24/7 house arrest.
All right,
on
so
GPS.
there's going to be sober support meetings 3 times per week, field visits 1 time per month until further notice. And I'm not going to order proof of employment because she's retired, but if she obtains employment, there's to be no employment. Sorry, excuse me. As a home health care provider or with minors. All right, is there anything else you need from the court to be successful?
No, ma'am, I would just like to say, Your Honor, that I'm very, very sorry. Words can't effectively convey the remorse I feel for ever having endangered a life. The safety of the community is the most important thing for anyone. I'd like to continue the life I've been leading since this incident happened, and that is a good Christian life. Practicing, putting God first and practicing my AA program daily, no days off. It's 24 hours a day, 7 days a week. And I'd like to continue that. I'd like to continue the help that I'm able to give others in recovery. And if I can help just one person not to drink and drive, then I'll feel very good. And I'd also like to thank you, Your Honor, your prosecutors, and your entire court staff for such grace and professionalism. I truly thank y'all. And this is truly a gift. And I thank you so much. And I thank God. Thank you.
Oh, thank you so much. You've made my day. I appreciate that. You're always on time. You're always dressed appropriately. I appreciate that.
Thank you, Judge Boyd.
In the end, this case lands exactly where the law often intends it to: accountability with structure. The court follows the plea agreement, imposing an 8-year prison sentence fully suspended for 8 years of community supervision. That's not leniency, that's leverage. One violation, and that prison sentence becomes very real. The conditions are strict and comprehensive: felony drug court, random testing, ignition interlock, DWI, education, victim impact programming, community service, sober support meetings, and limits on employment, especially around vulnerable populations. This is the justice system betting on rehabilitation, but with safeguards firmly in place. The judge's closing remarks are telling. This wasn't just about compliance, it was about effort, consistency, and respect for the process. Cotner earned probation not through words, but through months of documented behavior. Now we want to hear from you. Did the court strike the right balance between mercy and safety, or should the GPS have stayed even longer? If you found this case as compelling as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe to the channel for more jaw-dropping courtroom breakdowns.
Thank you. Have a good day.
You too.